All right, let's go over the real estate purchase agreement. These REIN documents are usually updated twice a year. Sometimes they make changes, sometimes they don't. So it's always important that you keep in line with the updates. This is our most current one from June 30th of 2022. So we're going to go through this, let you know how it gets filled out and what these different sections mean. So the purchase agreement, we're going to start with just like the basic information on when the agreement is being drafted. It's okay if there's like a day or two between the time that you draft it and the time that your buyers sell it, or excuse me, sign it, but you don't want to have like a huge gap. You don't want to sit there and write this for one day and then they're not signing it for a week or 2 weeks later because it's really going to mess with all your dates. So you want to try to keep your dates as close to possible as when they actually sign it. When you fill out the buyer's name, you do want to make sure it is their full legal name. If they have a common name, you want to try to make sure you include a middle initial or a full middle name. This is going to be how it is recorded on tax records, so it's important for it to be all the way spelled out. In addition to that, let's say that you have a married couple that have the same last name. You still want to keep their names completely separate. So it would be Mary Ann Taylor and John Smith Taylor, not Mary Ann and John Taylor. You want to make sure you have two separate individuals. And the same thing goes with the seller. You can usually pull up the seller's information by looking at the MLS. It will have it written out right here. So in this particular situation, it would be Garrett Hill and Gabriella Hill on the purchase agreement. The selling firm is actually always going to be the buyer's agent's firm. I know that that confuses people because we're thinking the seller selling, but it's actually selling firm for the buyer's agent because technically the buyer's agent is selling the property and it would be the MLS number. So in our situation, it would be Keller Williams Realty with our MLS ID of 9274. The listing firm you will locate on the MLS along with their MLS ID. It's usually located right below the picture. It says listing office and then the MLS number. This is one of our particular offices listing, so that's why it just says that. But it could say Wayne White Realty or Howard Hanna. All that information that you need will be located right there. When you are filling out the address portion of the purchase agreement, you're always going to start with the legal description. Again, this is something that you will refer to for the MLS for. It will be up in the right section over here to the middle. If you need to verify that this section, that this legal description is correct, you can always click on the realist form, which will bring up the tax records, and then you can verify the legal description there as well. Some legal descriptions may just be a number or be very small, so there might require some more specification, but typically you're going to go off of what is listed on the MLS. And then the next section is going to be the full address, the full street name, city, state, and zip code. The deposit is the earnest money deposit that your buyer is going to be putting down. This money is held in escrow until closing or termination of the agreement. The first blank is going to be the value spelled out, and then you'll have the numeric value here. So typically speaking, you'll do $500. So you'll have 500 spelled out with 500 over here. You could have an earnest money deposit that requires you to put more money down. We don't typically see less than 500, but we do see more. If it's a cash buyer, they may be putting down a couple of thousand versus just 500. Anything to kind of give them more leverage to make it look like they're a more serious buyer. And then if you're dealing with new construction, most likely they require 10% down because there's a lot more going in, a lot more risk going in for the seller who is building the property in new construction. You also need to specify how they are going to be paying it, whether it's personal check, federal wire, certified bank check, ACH, or other means. This is a discussion that you want to have with your buyers ahead of time, just to make sure that you understand how the money is getting to the escrow agency. Due to COVID and different situations, we have been embracing the federal wire transfer and the ACH a lot more, which has made it a lot easier for buyers to not have to take time out of their day to actually get their escrow money there. The escrow agent is typically the buyer's settlement or closing agent. In our situation, we would be Jones, Walker, and Lake that you would write right here. There are some scenarios where a listing agent will want the escrow money to be held by the seller's closing attorney, the listing side closing attorney, and that would be specified on the MLS, usually an agent remark. So you would put their closing attorney's name or settlement company's name in this blank as well. The escrow has to be paid to the escrow agency within 2 business days after ratification, unless it has already been paid prior to and is already at the escrow agent. So typically you will be checking this box here. It is very important that you drive this whole 2 business days after ratification home with your buyer. So if you ratify on a Friday, that means it needs to be to the escrow company by end of business day on Tuesday. Or if you do it on a Tuesday, it has to be there by end of business day on a Thursday. They need to understand that this is a very serious deadline and they have to get it done as quickly as possible. As a general rule, it's a good practice for an agent not to handle these funds and to make sure that the buyer is communicating directly with the escrow company so that you do not take on that liability of delivering those funds. We've had plenty of issues in the past where agents were supposed to drop off a check and then got really busy and totally forgot about it, and they had an escrow check in their car for like 2 weeks, and that actually puts your buyer in default. So you do not want to get caught up mismanaging funds like that. So encourage your buyers to handle it directly and make sure that they have all the information that they need. A closing company typically does send wiring instructions to your client when they want to pay for it that way. So just make sure that that is being orchestrated and communicated by you on all parties, and make sure that it does verify that it does get done in 2 business days. When you're looking at the purchase price, this is just means what they are actually offering for the house. So let's say that they're offering $200,000 for a property. You would do the numeric value here and then spell out $200,000 here. If they're doing a loan that is 100% financing, then you do not need to worry about filling out this down payment blank. Instead, you will come down here to this next blank where you would write 200,000 again, and then you would put the loan type. Some loan types that are 100% financing would be like the VA loan, or maybe a VHDA or a USDA, which has a government grant program that takes care of the down payment. But let's say that your client is doing an FHA loan, which typically requires 3.5%. So you would figure out what the 3.5% of 200,000, and you would write that right here. In this particular case, 3.5% is 7 grand. So you would write out 7,000. Do not put 3.5% here. Do not put 3.5 with a percent mark. That is not proper, and you will drive an agent crazy if you write it like that. So don't do that. So you're going to actually write out the 7 grand. And then in this box here where it talks about what is left over for financing, you will do your 200,000 minus your 7 grand, which would be 193,000 right here. And then again, you would specify FHA loan or conventional loan, whatever type of loan that they're using will go in this box. This box right here is reserved for a cash purchase. So if they are purchasing it $200,000 in cash, you would put $200,000 in cash here. However, in this situation, you would minus the $500 or $1,000 earnest money deposit, whatever that amount is, from that 200. So instead of it being 200, it would be 199,500. So just below the breakdown of the offer price and the down payment and stuff is the ratification box. This box is typically signed by the last agent who had the last set of initials to be signed off on. So if you extend an offer as a buyer's agent and the seller accepts it right away, typically speaking, the listing agent will be the one that ratifies this after their seller has signed off on everything. But if there's a communication back and forth with counter offers and stuff, then whoever has it last will typically sign off on it. If for some reason the contract is fully executed, but that agent did not ratify that, either agent could ratify it, and it's important to get it ratified as quickly. If for whatever reason your buyer is having cold feet, it's also important to communicate that as quickly as possible because it could be ratified at any point. At the bottom of each page of the purchase agreement, you'll see a set of initials for both the buyers and the sellers. You have 2 blank spaces for 2 buyers and 2 blank spaces for 2 sellers. If you only have 1 buyer, then only the first blank will be initialed. If you have more than 2 buyers, then you would create extra space down here for the other initials as well. Settlement expenses is just basically what we like to call closing costs. It can include just about everything that's listed out here. And typically speaking, you will judge how much closing costs your buyer is asking the seller for by the market that we're in. If you're in a strong seller's market, typically speaking, sellers aren't really paying the buyer's closing costs. So it's important to have that hard conversation with your buyer up front so that they know the expectations. Does not mean that you can't get the buyer's closing costs covered. It just means it's going to be more of a challenge. As we shift more into a buyer's market, you will see that roles reversed, and you'll see that you are not only able to get your buyer's closing costs covered, but you might be able to get a lot more than that, like a home warranty, maybe even some debt paid down as well. In addition to knowing what the market is going to allow as far as the closing cost covered, you're also going to need to communicate with the lender to determine how much the loan will allow. VA loans, you typically allow up to 6%. FHA, I believe, is 4%. And then conventional can be anywhere from 2 to 3% if conventional even allows it. Again, clarify with the lender. Some of these numbers may have changed over the years, but you would want to know how much you're actually allowed to ask for, because if you ask for 3% for a conventional loan and then find out later they can only qualify for 2%, this might change your buyer's mind about whether or not that they want to pursue that property or can actually afford to pursue that property. So you want to make sure that you know this ahead of time. Talk about it with the lender, talk about it with the buyer. Some really great verbiage for asking for closing costs was actually outlined uh, by our compliance broker, and this is the verbiage that we typically use right here. Seller to contribute 3% of the purchase price towards the buyer's closing costs, prepaids, points, funding fees, appraisal, title insurance, survey, inspection fees, settlement fee, and any other costs, including debt reduction at buyer's sole discretion and approved by lender. That's the most important part right there, approved by lender, because some of these things are not going to be allowed to have the closing costs cover in certain different loans. So you want to make sure that you're getting what you can actually get. We typically do 3%. 3% is very common in the area. Anything more than 3% is going to have a seller raising their eyebrow. So you want to try to keep it at the average. But let's say that you're at a lower price point, like $150,000. 3% typically of $150,000 is not going to be enough to cover your buyer's entire closing costs. So if the loan allows it, you might be asking for more than 3%. Again, stuff that you would want to discuss with the buyer and the lender to see what they need and what we can actually ask for. Right. You mentioned that last night.
On all of our clover lawn posts, we get some confused comments of people saying our yard looks terrible. It just looks like a bunch of weeds. Why would anyone ever do this? Grass is so much better. Well, we went on a walk today and thought we would show you the different grass lawns in our neighborhood. It's been over 100 degrees every day where we live, and we're also in clear down if you. The city's gonna break.
Okay, so down here in the deposit section, this is referring back to the earnest money deposit and how the funds are handled after you get it to the escrow company within 2 business days. The escrow company then has 5 business banking days after ratification to get that money into the bank. So notice the key ratification date here. So if you ratify on a Monday and your buyer does not get the escrow money to the escrow agent until the end of business day on Wednesday, that only allows an additional 3 business days for the escrow company to get it deposited. So it is important to stress to your client to get it to the escrow company as quickly as possible. Typically speaking, the escrow money is held in an interest-bearing account, and that is being disclosed because it's important for everybody to know that they may be making some money off of their money hanging out in escrow. It does typically belong to the person who holds the escrow account, and that is why it's being disclosed. The deposit will remain in escrow until settlement or termination. So if you settle, it gets applied to either your down payment or closing costs, or gets refunded back to your buyer in certain situations, or if it is terminated, then it's usually refunded back to the buyer unless otherwise specified in the release agreement whether or not the seller feels entitled to the earnest money deposit. That's a discussion for a different day, but that can happen, which is why you want to stick to all the contingencies within the contract and make sure we're following all the rules. So if your buyer does need to release, they're able to get their money back for whatever reason. The funds need to be released typically, if it is termination, it is typically sent within 15 days of such notice, meaning that you send a release agreement signed by the buyer and the seller releasing the funds. If there is a dispute on who is entitled to the earnest money deposit, it will sit in escrow until those things are settled upon. If a property is foreclosed, that null and voids and terminates the contract, so the earnest money deposit will be refunded back to the buyer within those 15 days. Loan application is just basically referring to who your buyer is going to be using to make sure that they get their financing in get their financing through. So you were typically going to write out the name of the lender here. I like to include additional information, which includes the loan officer's name as well as their contact information, like their email and phone number. If your buyer is still shopping between rates and they've got it narrowed down to a couple, then you would actually write both of those different lenders here as well, because as you've noticed in this line, if the buyer wishes to change lenders, buyer must obtain written permission from the seller. If you have more than one lender here, then you will have more than one pre-qualification letter showing that the buyer is pre-qualified through both of those lenders. And then you want to make sure that you get it specified as quickly as possible which lender they are going to use. Shopping around rates halfway through the deal is not a good idea. This will actually cause a delay in closing, and time is of the essence with this contract. You can have some additional verbiage here that you can get from our great compliance broker, Lucy, that will sit there and basically state that the buyer can change lenders without permission of the seller, but a new pre-qualification letter will be provided. Or some verbiage stating that if they needed to change their down payment, that they don't need to notify the seller of that either. You don't always have to include this verbiage, but if you know that your buyer is still shopping around for rates, you might want to go ahead and have that up here. But the safest bet is to have all the different lenders that they are considering listed on this line. The reason why I do the lender's full contact information so that if the listing agent, if we were in a multiple offer situation, the listing agent could reach out to that lender and verify that that buyer is a nice solid buyer and that they don't see any risk with the buyer falling through or anything along those lines. No obstacles to overcome, basically. Again, notice the signatures at the bottom of the page. You want to make sure that your buyer is initialing every spot designated for them. If there's anything that is struck through or written over when you see communication going back and forth, each change will also require a set of initials. We typically put those initials in the margin, but let's say that it is up here, we might be able to put the initials up there if it fits, but every change to the document will have initials next to it, but there definitely needs to be initials on the initial offer down here at the bottom of every page. These next couple of paragraphs is basically stating that the buyer is going to try their best to make sure that they are getting their financing. This just means that they are not going to neglect to get the paperwork to the lender when they ask for it. Some paperwork does take time to get together, but they need to do their due diligence and make sure they're getting everything as quickly as possible. And that they're also keeping everybody informed as to what is going on. So if for some reason they are struggling to get paperwork to the lender, they need to communicate that as well. And if there's for some reason why they're having cold feet or something is not working out, they have to communicate that. So if the appraisal came in less value than the purchase price, the loan is actually only going to cover the amount of the appraisal value. So you have to communicate that with your buyer's agent so the buyer's agent can communicate with the listing agent so that you guys can negotiate new terms, whether it be reducing the sales price down to the appraisal value or the buyer paying out of pocket the difference between the actual offer price and the appraisal value. Buyer's failure to comply with the provisions of 6A shall constitute default, meaning that if the buyer neglects to get their paperwork and attempt to get financing and get everything approved, they are in default of the contract and the seller has the right to terminate the agreement. Loan denial. Basically, this states that the buyer has to notify everybody if their loan is denied. The lender will notify the seller, the listing agent, the buyer's agent, all within 3 days of the denial. The seller at that point can choose to terminate the agreement or can choose to give the buyer opportunity to get more financing from a different company. If they choose to terminate the agreement, the earnest money deposit will be refunded back to the buyer. Now, this is typical when a buyer's unable to obtain financing. This does not have anything to do with the buyer's neglect. So if they're in default, then there may be a problem trying to get the earnest money deposit back. Typically speaking, you usually do get the earnest money deposit back, but you really want to make sure that it's because your buyer can't qualify and nothing to do with their neglect. Intent to occupy just basically states whether or not the buyer plans on living in the property. This is important to identify because some loans do not allow you to purchase an investment property. So if they plan on living there, you want to make sure you check that box. This is good for VA and FHA loans that have to live in the property that they're buying. If they're doing conventional or cash, it could be an investment property and they don't necessarily plan on living there. They plan on renting it out or flipping it, then they does not intend to live in the property. There are showings all day. Oh, yeah. Nothing set up for tomorrow. Which is why I told you to do it for Friday. So when we move on to the section of representations, we're going to kind of break down each section so that you understand how to explain it to your client. So section A says, otherwise specified in this agreement, buyer represents that neither this agreement nor the financing is dependent or contingent on the sale, settlement, lease, or refinancing of another real estate property. So basically this means that they don't have a property that they need to sell or lease out in order for them to qualify for their loan or for their ability to purchase. If they do, it is okay. You're just going to specify that in the later blank further down the contract, which we will highlight later. Section B, buyer acknowledges that the seller is relying upon all of the buyer's representations, including without limitation the accuracy of their financial information given by buyer to seller. So basically, this is the buyer understanding that the seller is accepting their offer, that they are being truthful and forthcoming with their information, that they are not trying to deceive anybody about their ability to qualify, and that they're going to make sure that they do everything that they can to get qualified and get their loan fully financed so that they can purchase the property. If they were to find out anything that was going to keep them from being able to purchase the property, that they notify within 3 days receipt of whatever that is in writing, basically an email to let them know. That way the seller has the ability to decide what they want to do, whether it's terminate the agreement or try to work with the buyer further. Section C, except as expressly provided below, seller represents that the seller owns a good and marketable fee simple title to the property and has the right to transfer the property. It is important for the title to be nice and clean so that there's no title defects that they have to sort out later. But it's more importantly that the seller actually has the right to sell the property. Let's say that the listing only has one seller's name, but if you look at the tax records, you verify that there's actually 2 names on those tax records. It's important for you to do your due diligence as a buyer's agent and ask the listing agent why only one person is listed up there. This could be because somebody passed away. This could be because they're going through a divorce. There's a lot of ins and outs that could cause some kind of issue later, but you want to make sure that you understand what's happening and that this deal can actually go through as well. And they would specify anything here specifically, like if they were having to sell it because of a divorce, they would specify that here as well. Section D, except as noted below, seller represents and warrants that the seller is not a non-resident alien, foreign estate, foreign trust, foreign partnership, or foreign corporation, as those terms are defined in the Internal Revenue Code and applicable United States Treasury regulations. This just basically states if they are, that we need to do some additional get some additional information and additional forms filled out so that we can go ahead and continue on with the purchase or the sale of the property. Section E, seller also represents and warrants that the property is not served by an on-site septic system. On-site septic system not subject to a waiver, or the property is served by a septic system that has a waiver or other. So if you are in a rural area where there is a septic system, then you would need to fill out one of these two or three blocks down here. Typically speaking, if you are in the city and it's on city or county water, then or county sewage, this is the box that you will most likely be using. Now, if it's on a waiver, typically the waiver just means that at some point they expanded the property. Let's say that the house was built in 1988 and they decided to add an addition to it, but the septic system was set up for 1998 for 3 bedrooms and they're actually adding a 4th bedroom. They could petition the health department to get a waiver that will allow them to not have to redo the septic system. It's important for you to make sure if there is a waiver in place that the waiver does convey with the property over to the next buyer and that it's not going to cause an issue where your buyer is having to get a new septic system built because that is expensive and it requires a lot of moving parts in order to do that. F, if representations by seller is materially untrue, seller shall be deemed to be in default under the terms of the agreement. The buyer has the right to terminate this agreement. So basically, just the same as the buyer being untrue, the seller could be untrue as well, which would put them in default and allow the other party to terminate the contract if they want. If settlement does not occur as a result of seller's misrepresentation, buyer incurs any expenses relative to appraisal and property inspection, the seller could be deemed liable for such expense, and the buyer may have rights to basically sue and go after that cost. This is an extreme case where if the seller was being intentionally neglectful and trying to trick the buyer into purchasing, and you were to find out later when you're very well into the deal, you could pursue that. At that point, you would want to refer them to an attorney and to figure out the next steps, what they're doing. Settlement and possession date. Typically speaking, when you set the settlement date up for 30 days after their initial offer, you may even want to do 32 if you expect there to be some negotiating back and forth. If you are doing a cash purchase, this does not mean that you have to wait 30 days. You might be able to get it done sooner. You still want to allow for enough time for title and stuff to be pulled. So typically speaking, 30 days, sometimes 45 if you're dealing with different types of lenders that do take 45 days to get stuff processed versus 30. The settlement date may be extended by, if left blank, 10 days. I usually always fill it out because I don't like blank spaces if I don't need them. And the only solely for the purpose of one, processing and closing the specified loan in compliance with applicable law, which that pertains to the buyer. So if they have financing stuff that needs to be sorted out, they can utilize those 10 days, or correcting any defects reported by the title examiners, which means the seller side. So you get 10 days under this exception for the buyer, 10 days under this exception for the seller. The settlement date shall be deemed to include any extension only as provided for 1 and 2. Now, that does not mean that you cannot extend the settlement date. It just means that's going to require an addendum to go ahead and draft it out. Even if you're utilizing these two areas for your additional 10 days, it's still good practice to go ahead and do an addendum basically stating that the buyer and seller agree to change the settlement date from the original settlement date, then the new settlement date, and then have everybody sign off on that. And as you notice, again, there are initials for your buyer and seller to initial off on. As we scroll down to the next page, we're going to see a bunch of legal jargon where it just basically states the rights of the buyer and the seller, choice of settlement agent. Yes, we have a relationship with Jones Walker and Lake, but when it comes down to it, it is up to your buyer on who they want to choose to use for closing. 9 times out of 10, they're going to use who you recommend because you're the expert in the field, but maybe they have a relationship with another title company and it is their choice to use that. The buyer settlement agent is the one that collects and disperses the funds, and typically everything is recorded within 2 business days after settlement and dispersed on the day after it is recorded. Variation by agreement. This just basically states that the seller may not require the use of a particular settlement agent as condition of the sale of the property. You may see some sellers that are offering incentives if you use the seller's closing company, but they cannot make it a part of the agreement. There are some blurred lines where people try to get away with it, But in reality, if the buyer is using the seller's closing company, that closing company represents the seller, so your buyer will actually be sacrificing some representation at that point. So I always try to make sure my buyers have their own settlement company and not using the same company as the seller. And this even pertains if the seller so happens to be using Jones Walker and Lake. At that point, I will get my buyer a different settlement company because I want to make sure that they have proper representation. Escrow and closing and settlement service guidelines is just basically stating that they have the right to choose. The Virginia Bar issues guidelines to help settlement agents avoid and prevent the unauthorized practice of law in connection with furnishing escrow, settlement, and closing services. As a party to a real estate transaction, the buyer is entitled to receive a copy of these guidelines from the settlement agent upon request and according to provision. This just basically means that we're not going to have any undisclosed items. Basically, everybody's got to be upfront about what they're doing and how they're doing business. Buyer and seller each authorize their respective attorneys, lenders, and or settlement agent to furnish prior to the settlement date to all parties, including listing firm and selling firm, complete copies of the draft and final closing disclosure settlement statement for the sale of the property, including the HUD-1 settlement statement, the TILA RESPA settlement statement, the ALTA settlement statement combined with the seller's closing disclosure, aka seller's disclosure, the buyer's closing disclosure. We typically usually receive these a day or two prior to closing. This is a good idea for agents to go ahead and review that to make sure that everything is going to be on there that needs to be on there, aka your commission looks correct. Our office admin fee, that's a big one. It's $3.95. If it's not on that HUD, that means it's going to come out of your commission check. So you want to make sure that it is on that HUD so that it's getting paid by the client. Also, if the buyer's supposed to be getting closing costs, you want to make sure that that is reflected on the amount. If there was any repairs done and those people are getting paid out of closing, you want to make sure that that is on there as well. So it's important for us to get this a day or two ahead of time so that we have time to actually sit down and review it. And we can go over what these documents look like and how they break down so that you do know how to review them at a later date. Deed and title, except as expressly provided in writing, representations and warranties made by the seller herein and all other provisions of this agreement shall deemed merged into the deed delivered at settlement and shall not survive the settlement unless otherwise provided here. So this is just basically stating that they're putting forth a good title. If there was an easement that conveys with the property, it needs to be identified as well as any covenants. Or if for some reason that this is not a general warranty deed, that would be specified here as well. So if it's like a bank-owned property, it may be a special warranty deed or something like that. Also, here's an opportunity where I take how it's going to get recorded if it's a married couple. Like if I want the married couple to be recorded as tenants by the entirety, which basically allows the deed to be recorded to where if the husband or the wife or the other part of the couple were to pass away, that the entire property would then pass over to their significant other versus only 50%. Touch and go about whether or not you can put that here. For the most part, I don't ever have any issues with anybody having an issue, kicking it back saying that that's not right. But, you just want to get some additional verbiage, but it would typically be their first and last name to be recorded as tenants by the entirety. Section B, buyer will be required to purchase lender's title insurance. It's important that the buyer understands that the lender's title insurance only protects the lender, it does not protect the buyer. They can purchase their own coverage, which is a very good idea because if something was to pop up on the title later on, that insurance will kick in and take care of that because they have title insurance. Even if they own the property for 20 years, then turn around and try to sell it, if something was to pop up on their title, that title insurance would clear that up. So let's say that the property was getting some work done on it while you guys were under contract, and that contractor was supposed to get paid out of closing for whatever reason didn't. That contractor has the right to put a mechanic's lien on the property, which stays with the property. It does not stay with the seller. At that point, that title insurance could kick in and take care of that as well. The right for a survey, they can get a survey if they want to. It's going to depend on the buyer. They can get a survey done at any point in time. They don't have to do it during the contract period. But if getting a survey is important to them to make sure that they know where their property lines are, to make sure that there's not any kind of encroachment going on, and maybe they need to make sure that like a pond, if they are buying several acres, is on their land or not, getting a survey may be very important to them, which is usually organized by the closing company, and you would want to make sure that they have the right to get that done prior to closing. Again, initials. Every single page has initials. Prorations and escrows, basically you're identifying whether it is new financing or cash sale, or if it's an assumption. We don't have too many assumptions going on right now. And from my understanding, the only type of loan assumptions that you can do are VA, which means the buyer has to be VA as well. This is something that you would discuss with the lender to know ahead of time, and that's when you would be filling this out 9 times out of 10, more like 99 times out of 100. You're going to you're going to check this box right here where it's new financing or cash sales. This next area is where you're actually going to specify the type of funding that you're using, whether it is going to be HUD, FHA, or VA, conventional financing, or cash. You will be checking one of these boxes, not all of these boxes. If you are doing this first box, you need to make sure that you talk about the appraised value, which will be the purchase price that you put in here. So 200,000 will go right here. You could do the amount where it is the amount that they're actually financing after their down payment, but it is your best bet to put 200,000 just to make sure that we're covering the entire actual offer price. The conventional financing, you would put right here, and then you would want to make sure that you understand as far as the appraised value. Seller does not agree to reduce the purchase price to the appraised value. Buyer shall have the privilege and option of proceeding to settlement without regard to the appraised value. They can proceed to settlement regardless of the appraised value here, but it is out of pocket money. So same thing with conventional. If it does not appraise, they would be paying the difference out of pocket. So you want to make sure that you specify whether or not you need that appraised value to be contingent for the contract. And then of course, cash, you can elect to get or not to get an appraisal at that point as well. Appraised value with respect to paragraphs 11B and 11C above. If for any reason the appraised value is less than the agreed upon purchase price, buyer shall have 3 days, that is 3 days, not 3 business days, from receipt and notification of the appraised value to the seller to either A, agree in writing to proceeding to settlement without regard to the appraised value, B, negotiate with the seller to find an acceptable agreement. If after 3 days, buyer has not agreed to proceed to settlement regardless of appraised value. Seller has not agreed to reduce the price to the appraised value, or an alternate acceptable to both buyer and seller has not been agreed to in writing, then neither buyer or seller may terminate this agreement. If terminated, buyer and seller shall execute the release in full, refund the deposit to the buyer. So no matter the type of loan or type of funding, you have 3 days to decide if it comes under value, what you want to do. If you can't come into an agreement, the contract is terminated. Property condition, this is just basically stating that the buyer is attempting to purchase the property in its current condition at the time of showing, meaning the items that are there that are meant to convey are supposed to be there when you go to closing. It's supposed to still be in the same shape. It's not supposed to be completely destroyed. If there is some repairs that have been specified in the MLS that's going to take place, but it is not listed, it's not done yet, you can actually put that here. So property condition would be, seller to have the house painted back to the original color, or, the dishwasher to be replaced, whatever the case may be, you would outline those conditions in here. Seller shall repair or replace the above noted items in a workmanlike manner at seller's expense prior to walkthrough inspection. This actually has nothing to do with the home inspection and anything that you guys agree upon there, but it's important to understand what workmanlike manner is. workmanlike manner means that it needs to be done the way that it's supposed to be done. However, it is still very much a gray area, so you want to make sure that you include verbiage as approved by buyer as well in there, just to kind of protect your buyer a little bit better, to make sure that things are getting done the way that they're supposed to. Seller shall deliver the property at settlement or as otherwise provided in substantially the same condition as the date of this agreement, and except as provided in paragraph 15, free of personal property, debris, and trash. Seller assumes until settlement all risk of loss or damage to the property, fire, windstorm, casualty, or other hazards. So basically, this means that the seller is supposed to deliver a vacant property at that point. It does not actually specify clean. So if the property is dirty at the time that you show it or the time of walkthrough, you would want to attempt to try to get that resolved prior to, because it's not in the purchase agreement. So if it is dirty at the time of purchase, at the time that this offer was drafted, you would want to specify in here property to be professionally cleaned 3 days prior to closing after seller has vacated the premises, something along those lines, because if that's important. But you cannot, your buyer would be in default if they refuse to close just because the property was dirty, unless it was like, it would have to be aggressively dirty. Seller assumes all risks. This just basically means if you're under contract, a tornado blows through and blows the roof off, that actually still falls on the seller and not the buyer. But if you have signed and the deed has been recorded, it could potentially fall on you at that time. So that's where the question in play comes, like, when does settlement actually happen? When did the damage actually happen? So, but it's the seller's responsibility to continue to maintain the bills, continue to take care of the house throughout the entire contract. This section here came about basically when we were dealing heavily with COVID, because a lot of our showings became virtual. So it would basically have to specify whether or not the buyer has physically seen the property. This does not mean they physically saw it through the lens of a camera. This means that they were physically in the property and walked the property with you. If they have not, then you will attach the no physical inspection addendum to this purchase agreement when you submit your offer. So as we look over the wood destroying insect infestation, moisture inspection / repairs, this is regarding the termite and moisture inspection. You have to specify whether or not the buyer is picking or the seller is picking, or and who's paying here. Typically in a seller's market, you would either see a buyer pick and pay or a seller pick and pay. In a buyer's market, the buyer picks and then the seller pays. You can actually rearrange this combination however you're comfortable. And in this section here is where you're going to specify any dwellings that are not attached to the house. So if there's a shed out back that you want to make sure is a part of the inspection as well, you would include that here. Typically, we like to try to get these done as quickly as possible as well with a home inspection. So I typically try to write it within the same timeline as the home inspection. If the seller is picking or paying, they may elect to get it done after the home inspection time frame, just to make sure that the contract is still moving forward. You're going to spell out the amount of days, and then of course write the numerical value there. The price of the the termite moisture inspection is actually going to depend on who's doing the inspection and where it's located. If you're in a more rural area, sometimes the inspections can be a little bit more expensive. But typically we put something along the lines of $100, and it just basically means, you can pick the termite moisture inspection not to exceed $100. Of course, make sure you initial down there at the bottom. I don't think I could drive that point home enough, but we do have another 8 pages for me to point it out, so we'll see. Treatment, if it is required, is going to be performed by the same company that is actually issuing the report, meaning if you use Pest Out to do your termite moisture inspection and they say that a treatment and repairs are necessary, they will do the treatment. Repairs can actually be contracted out. Most termite moisture companies contract it out anyways, and they have a contractor that they typically work with, but the seller can elect to have a different company do the repairs as well, but they can't do the treatment. So once those repairs are done, you can have the same company that did the original inspection go out and just confirm that everything is done properly. Typically, they don't do treatment until after the repairs are done anyways. So drinking water and septic, if it is on public utilities, you just need to check this box and you don't really have to go any further than that. If it's on a well, then you can elect to either have the buyer or the seller obtain an inspection for the well prior to closing, which will be at the buyer or the seller's expense as well. Usually when they're doing a well inspection, it's just to determine that the water is acceptable and that you're actually going to have water for a significant amount of time. Most of the wells are dug pretty deep and it might be like 100-year well, but if the well is really old, it may be close to drying up and may need to be redug or might be contaminated, which is why this inspection is important. The septic system, it's pretty much kind of like the same thing as the well. You're going to determine who's going to order the inspection and who's going to pay for it. The inspection will include it getting pumped or not. Septic system typically need to be pumped every 3 to 5 years. So if it was pumped relatively soon, then you may elect not to have it pumped. But if it is getting close to that 3-year mark, you may elect to go ahead and have it pumped. In the state of Virginia, it's actually quite common to get the seller to pay for that in our area. But if you are dual license and you're doing North Carolina, it's actually the opposite. The buyer pretty much pays for everything. So just keep that in mind, little pocket note for later. And of course, if there was any type of repairs or something that needed to occur, like this would fall under the cap required repairs. So as long as we're not exceeding that 1%, that $2,000, your buyer shouldn't have an issue with getting these repairs taken care of. The walkthrough inspection is regarding the utilities. The seller is supposed to have the utilities on the entire extent of the contract until after closing. So if the closing has taken place that morning, then the sellers could indeed have their utilities turned off by that afternoon. Typically, they have them turned off the very next day. So you always want to make sure that your buyer set up the utilities prior to closing. So they can actually contact the different companies and let them know the day that they're planning on closing so that you have a nice smooth transfer. Especially if they are closing on a Friday, the last thing that you want is for your buyers to go all weekend without any type of utilities. Now, there are some properties like REOs, foreclosed homes, that may not have the utilities on. They may be winterized, which just means that they don't have any water or any kind of utilities onto them whatsoever. Usually those type of properties, the seller will not have the utilities turned back on. So it will actually be the buyer's expense to have the utilities turned on for that particular day of those inspections and to have them turned off afterwards. So if you have a situation where you're assisting a buyer purchasing a property like that, just get with one of a more tenured agent and they'll be happy to walk you through everything to make sure that you understand the process as well. Now, as we move on to section 14, where we start discussing contingencies, contingencies is basically different things built into the contract that could cause the contract to fall apart if the contingencies are not met. The first section here is talking about it being a condominium. If the property falls into a condo association, then we need to disclose that here as well as the monthly amount of what the condo association fees are. Now, some condo associations charge it yearly, but because this states monthly, you want to get the monthly breakdown. Now, you can typically find that on the MLS located at the bottom where it talks about condo fees or HOA fees or POA fees, which means property owners association. So it'll be listed down here, and you would also find the contact information for the HOA just to make sure that you can disclose that as well to your clients. And again, there's my initials. Let's make sure that we don't ever miss those initials. Now, there are some new builds that may not technically be in a condo association, but will be in a condo association after everything is finished. So you would be checking that. So if you're dealing with a new construction, again, this is one of those things where you want to get yourself with a more tenured agent who's used to new construction because it's a whole nother playing field and you want to make sure that you're getting all of your disclosures right. Now, if you're in a condo association of 3 or fewer units, they could be exempt from the Condo Act. It may still be a condo association, but they don't have to fall under this category of including the resale documents and the associated paperwork with that. Again, it will be disclosed on the MLS if that is the case. Property Owners Association is very similar to a condo association. However, the fees aren't typically as high as condo associations, and the rules are going to be a little bit different because these are usually individual properties where they own the house, but they're part of a community association. Whereas a condo association, you can't ever separate the condo from the other units. So you just want to clarify whether it is or is not, and then what the fees are if they are in there. A co-op means that a business actually owns the community, and you would want to clarify this. There's not too many co-ops in our area. They do exist, but there's not too many of them. So this is going to fall under that same category where if you do come across one, you want to make sure that you discuss it with the attorneys and a tenured agent to make sure that your buyers really understand what it means to be buying into a co-op and what the fees are and what all that entails as far as being a part of that association. Property inspections is another contingency that is typically built into the purchase agreement, and most of our buyers, as we want to encourage all of them, should be getting a home inspection. A home inspection is not mandatory. It is something that the buyers elect to do, and it is at the buyer's cost to get the inspection done. But by including a property inspection contingency, which is the PICA, you would create the opportunity for your buyers to release from the agreement if the house is in much worse condition than they anticipated, or if you cannot agree on repairs for you and but for the seller to perform prior to the closing. So it is a nice safety cushion, but more importantly, it gives your buyers a full understanding on the top of property that they're buying and letting them know the overall condition. Exterior insulation and finish system. This is also known as ephesus or stucco. You will see stucco at some of more oceanfront type properties. You do see it in certain neighborhoods where you might see it on like a pillar. If the exterior of the house has a lot of stucco, there may need to be a ephesus inspection over it. Basically, what happens is the stucco will get these very small cracks that may not be visible unless you're looking for them. And when you have those cracks and they're not properly repaired, moisture can get behind that and in between the actual house itself and the stucco, which will create a huge problem in the future, a very expensive problem. So if your buyers are trying to buy a house that has a stucco finish, you definitely want to encourage them to go ahead and have this inspection done. Lead-based paint disclosure. So if a property was constructed prior to 1978, the paint used back then definitely had lead in it. Lead-based paint disclosure is attached to every property that was built prior to 1978, regardless of how many times they painted or whether or not the drywall has been taken down and replaced. So you want to make sure that if it has been built prior to 1978, that your buyer decides whether or not they want to have a risk assessment or waive that right. This is an inspection that will get very costly and be at the buyer's expense. It's important that you make sure that your buyers have a copy of the Protect Your Family from Lead-Based Paint packet that is a part of our buyer consultation packet, and make sure they understand the risk when it comes to lead-based paint. It's always been my understanding after it's been painted over quite a bit, and as long as the paint is not chipping, that there's not really a whole lot of risk there, but it's more important for your buyer to be able to make this decision for themselves. 9 times out of 10, a seller is going to disclose that they have no knowledge of lead-based paint and that there's not anything for them to share. Lead-based paint is very common with any house built prior to 1978. So just keep your buyers informed. That way you can keep the deal moving forward. And of course, make sure that your buyers and your sellers do initial this page as well. Other inspections, if the buyer desires any other inspections, it's going to be disclosed on the property inspection contingency addendum, which is also called the PICA. That is the one that you will attach to every purchase agreement when your buyer is getting a home inspection. Other inspections could include like your pool inspection, or if there is something else on the property that is unique that isn't typically within the scope of a home inspection, like maybe structural engineer needs to come out and look at something, that is where you would disclose the type of inspection that your buyers would like to get. Again, these inspections are at the cost of the buyer. Other contingencies is where you're going to map out if the buyer has something else that can keep them from being able to purchase the property. Like when we read earlier regarding whether or not they had a house that they needed to sell or rent out prior to being able to purchase. So if they do need to sell a house, then you would state in here, purchase of this property is contingent on the sale of whatever house that they're selling. And you need to also specify whether or not that house is listed on the market or under contract as well. All of this information is very important so that we all know that where our timelines are and the risk of accepting an offer that's contingent on the sale of another property. Items to convey. So if it's a part of the property, like the cabinets are expected to be considered a part of the property, but some of the other things that might be easily removable, you want to make sure that you clarify on your purchase agreement the items that are staying. So that's going to include like the stove, the microwave, the fridge, different items like that. So you want to make sure if it is at the house and listed on the MLS to convey, that you check it off on here. There are some things that may be at the house that aren't technically listed on the MLS. So you would want to make sure it's on the purchase agreement if your buyers want it. For example, not every listing agent is going to check that there's a garbage disposal, but there's a lot of properties that do have them. So if you see a garbage disposal, go ahead and make sure you check that box as well. And as far as all of the other items, if it does not pertain, you just leave it blank. If there's additional items that aren't listed up here, let's say the house has a whole house generator. Most of the time, those are hardwired into the house anyways, but you want to go ahead and put some specifics in there and make sure that you write in there whole house generator to convey with property. You can also put some additional verbiage that says at no additional value. That way it does not affect the appraisal value in any kind of way as well. Confirmation and disclosures. This is just basically where we're going to talk about the confirmation of our brokerage relationship. Majority of the time when you are disclosing the relationship, it's going to be utilizing number 2, which is listing firm and its salesperson represents the seller, selling firm and its salesperson represents the buyer. This basically means that there's a different brokerage representing the seller and a different brokerage representing the buyer. The first one is regarding an unrepresented party. So the listing firm, selling firm, and their salesperson represent the seller as their client. Buyer is unrepresented party, and their salesperson represents seller as their client. So you would sign the disclosure basically stating that the buyer is unrepresented. So if you are representing your seller and somebody wants to purchase the property that does not have an agent and does not want to work with an agent, this is the one where that would come into play. Number 3, listing firm and its salesperson represent the seller, selling firm and its salesperson represent neither buyer nor seller. So this just basically means somebody filled out the paperwork for that buyer, but isn't actually representing them and expecting any type of commissions for that. I personally have never used this one yet, so it's definitely going to be a unique situation when you do come across that. Usually we have some type of agreement in place. Number 4, the parties confirm that the selling firm and its salesperson represent buyer as their client. Seller is a customer unrepresented as party and has signed the disclosure. So this is the same thing as number 1, but this is the seller being unrepresented. So if you have a buyer that wants to buy from a for sale by owner, this is the box that you would be checking. Number 5, listing firm and its salesperson represent both buyer and seller as dual agents or dual representatives by mutual agreement. And then you will have a disclosure for dual representation. Dual representation is legal in Virginia. However, our office at Keller Williams do not allow for dual representation. That means the same agent represents both the seller and the buyer. Instead, what we do at our office is a designated agency, as highlighted at number 6, where it can be the same brokerage but two different agents. So if you find yourself in a situation where one of your buyers wants to actually purchase one of your listings, you would need to find a buddy that you work with and pass off one of your clients. Typically, I end up passing off the buyer because I've already have a very well-established relationship with the seller and know a lot of ins and outs. This will allow the buyer to have good, thorough representation, and it also allow you the opportunity to at least get a referral fee off of that transaction. So you're still not walking away without losing money. Number 7, buyer or seller acknowledge that no brokerage relationship exists with any agent involved in this transaction. Both buyer and seller are unrepresented customers. Again, just like the number 3 up here, I've never actually used this one, but it's pretty self-definitive in the explanation. Nobody actually has a relationship. The next disclosure that we're going to discuss is the aircraft noise and accidental potential zone. This is also called the ACUS. In the cities of Norfolk, Virginia Beach, Chesapeake, or Hampton, there is always going to be an ACUs associated because we have aircraft military bases there. Now, when you're discussing the level of noise, it's going to be listed under the MLS on what their noise zone is. You'll usually see it right here under ACUs. And then that is how you fill that out. So if the noise level will go right here, let's say it's -65, you would write -65. If it's near a crash zone, you would write the term for that, or you would just put NA or none. If it is not in a noise zone, then you would literally you would just check off this NA right here that it's not applicable. But if it is in Norfolk, Virginia Beach, Chesapeake, or Hampton, regardless if it is in a noise zone or not, that this disclosure will be attached and needs to be signed. The Virginia Residential Property Disclosure Act, aka the DPOR, is attached with all listings. So there should be one uploaded unless it is a new construction or unless they have exemption from from having to provide one. Some REO properties or foreclosed homes don't have to provide one. So if that disclosure exists, you want to make sure that your buyers have it to sign off on at the time of putting forth the offer. Agency interest disclosure is just basically discussing whether or not an agent is related to their client. So if the seller owns the property, if a listing agent owns the property that is being sold, they would have to disclose that they're either the owner or that they are related to the owner. And that works on both sides. So if you are working with one of your family members, then you would need to disclose that as well. Megan's Law is actually regarding the sex trafficking or sexual offenders register. We always encourage people to look up the site themselves if it is a concern for them. We do not look up the site for them. We do not do any research like that. It's important that they do their own research because you don't want to get caught in a situation where you're creating a liability because you either told them everything was good or you told them everything was bad. You just give them the resource and let them do the research that makes them feel the most comfortable. Mechanics lien, we discussed that a little bit earlier when we were talking about title insurance. So a mechanics lien is something that can be put on the property after a contractor did not get paid, basically. So if they do work for a property, they have 90 days from the last day of the month in which the lien or last performed work or furnished materials, or 90 days from the time of the construction, removal, repair, or improvement was terminated. So 90 days, 3 months from the time that they've last been on the property or did the work, they can put a mechanics lien on the property, which conveys with the property. This will make it hard for you to sell the property without taking care of that in the future. So if this occurs prior to you purchasing the property and it wasn't filed until after you purchase, this is where your title insurance will kick in and take care of that. So make sure that everything gets paid by making sure that you have a copy of all the invoices from the different work and making sure that the title company has that so they can ensure that they're getting paid. Square footage and acreage and other property measurements. This is just basically stating that all of that stuff is approximate and that what we have is what we have, and it's up to them to make sure that they are comfortable with it. Pending building or zoning violations. If there was any pending building or zoning violations, the seller is supposed to disclose that. That's part of what falls under the D4. Typically speaking, they should be able to go to the city in which they are purchasing, be able to plug in the address and research this information themselves as well. If you know that they're in an area that's going through some development, this might be important because this could affect the roadways that are out there. This could affect whether or not they can continue to park the way they park. And you also want to double check and make sure that if there was like any additions done to it, they may want to make sure that proper permits were pulled, that kind of thing. So there's plenty of information for them to look up if this is something that may be concerning for them, but at the same time, the seller is supposed to disclose of anything that they might be aware of. Same thing with it being a meth lab. They are supposed to disclose if they have the knowledge of that. It is my understanding that if it was used as a meth lab, it has to basically be torn down the studs, treated, and basically rebuilt at that point. So it's almost a tear down. But if they don't have knowledge, they're pretty, and most of them don't, if they didn't use it as a meth lab and it's not on the legal records or whatever, but they are legally obligated to disclose if they are aware of it. Brokerage fee, this is just basically talking about the selling firm and listing firm are intended to be and are third-party beneficiaries of this agreement with respect of payment of the brokerage fee and are entitled to payment at settlement as provided by separate agreements. Typically speaking, the listing agent during their listing agreement will determine the commissions that are being paid for out of the seller's net proceeds, which is typically 6% in our area. That is actually up for negotiation, and it's not defined line, and it's actually not to be discussed on other different social media platforms. So you want to make sure that you're real careful when you're discussing commissions. So as a general rule, discuss commissions with other agents in person and not necessarily out for the internet and the world to see. But the listing firm determines how much the commission is being offered by the seller. And then there is a separate brokerage fee agreement that you will attach to the offer over to the listing agent for them to sign off on. That you will be able to consult the MLS on how much they're actually offering for the commission. Like this one says, the SBCs means selling brokerage commission. So 3% is what this particular listing agent is offering for the buyer's agent. So when you fill out your brokerage fee agreement, that's what you would be putting in there is the 3%. Default, basically this, if the buyer or the seller was to cause any kind of default with the contract, subject to the provisions of the paragraph 19 below, if either party defaults under this agreement, the non-defaulting party may pursue, in such party's discretion, all remedies available to the non-defaulting party at law or in equity. This could mean the earnest money deposit. This could mean additional funds. Like, let's say that the seller defaulted and didn't disclose that they actually don't have the legal right to sell the property, and your buyer has already done home inspections and appraisal. Your buyer may have the right to go ahead and pursue selling the seller for the expense of that. And if we do this vice versa, where the buyer was lying about their terms on where their eligibility to buy, went through the entire contract, through all the contingencies, and gets to closing and changes their mind about closing, the seller at that point could choose legal action as well, which could include the earnest money deposit, as well as any fees that they may have endured or lost market time as well. So it is very important for you guys to understand your timelines and your deadlines throughout this agreement, because if your client is having second guesses about whether or not they want to continue finishing the contract out, you want to make sure that you give them the window of opportunity as it exists so that they can get out of the contract without losing any more money. Dispute resolution, this is just basically talking about that your clients have the right to do any kind of litigation. Typically what I do when I'm talking to my clients about this is I talk to them and I let them know if there's an issue that I cannot resolve because I'm there to speak on their behalf, that we could get our brokers involved. If we can't come to an agreement, and it can go further from there, they can seek out legal action as well and go through mediation and take it all the way to court if that's something that they want to do or need to do at that time. Make sure your buyers and your sellers are initial in every page. Other provisions. So this box is left blank and it is intended for you to write whatever it is that you need to write in here. This could be other provisions. This could be something that your buyer is providing for the seller. This could be something that the seller is providing for the buyer. This is where you can state buyer agrees to pay $2,000 above the appraisal value in the event that the house does not appraise for the purchase price, but not to exceed the purchase price. Or this could be seller to buy the buyer a home warranty of the buyer's choosing not to exceed $550. There's several different things that you can put here. The reason why we're putting it under other provisions is because it's not an actual contingency. It's not a deal breaker. It's just something that you're trying to get done for your client and you want to make sure that you have it out there. Non-assignment just basically means that this agreement cannot be assigned by the buyer without a written consent of the seller. So they cannot take this deal and give this deal to another person without written consent of the seller. Tax deferred exchange. In the event that buyer or seller desires to effect a tax deferred exchange in connection with the conveyance of the property, buyer and seller agree to cooperate in effecting such exchange. Basically, you will know about this ahead of time. This is typically when you are dealing with investors and they are moving different property, or if the buyer is selling a property and turning around and purchasing another one in another place, they will know about it, they will speak on it, and you will make sure that their closing companies has everything set up so that they can make this a streamlined process for them. Notices, except as provided below, all notices required to be sent to seller under this assignment shall be sent to the listing firm, and all notices to be sent to the buyer shall be sent to the selling firm. So this basically means that you're going to use your channels and communicate through the listing agent for anything that the seller needs, and vice versa for the buyer. So if your buyer wants to ask if the seller will be willing to leave some china cabinet that's in the dining room, instead of the buyer going directly to the seller, the buyer is to communicate that to you as the buyer's agent, where therefore you turn around and communicate to the listing agent, and the listing agent communicates to the seller. There are other means of who's going to be dealing directly with your client. So like if you are representing the buyer, their lender will deal directly with them, the title company would deal directly with them, but you will always be kept in the loop. Electronic means is going to be email, basically is going to be the main course for communication. Of course you will have phone calls and text messages, but you want to make it a good practice to go ahead and follow up after those phone calls and text messages with an email to the other agent to make sure that you have a nice transcript of the communication going back and forth. There could also be stuff that is getting mailed and hand delivered and overnighted and everything along those lines, but electronic is going to be your main avenue for communication. Miscellaneous is just a little bit of a definition paragraph where they talk about the term day, meaning any day of the week, Monday through Sunday, regardless of holidays or bank days, and then business banking days, Monday through Friday, except for federal holidays. Typically speaking, the day is going to be from 12 a.m. to 11:59. If you see end of business days, that is usually 4 or 5 p.m. But you want to make sure that you specify if you need something by 5 p.m. You want to make sure that you actually are very clear about that deadline. Otherwise, it could be interpreted to 11:59 p.m. Don't forget to initial. This box here is talking about acceptance of electronic signature. Just about everything we do is a digital age now, especially with COVID. So by your clients initialing here just means that they accept that everything that we're going to be using digital signatures for several different documents throughout this entire process. And yes, they do have to initial here too. This last page is the signing page, and you are going to need to fill this out to the best of your ability. It's most important to make sure that you do have your buyer's address listed up here, even though they are buying a property and moving, hopefully moving into the next property. There's 2 slots for buyers to sign. It needs to get dated. Selling agent, that is you as the buyer's agent with your firm's name, address, REIN ID, license number, and then it's going to have your name, your REIN ID, and your license number. And then we have the same section for the sellers. If you have all of the listing information, go ahead and fill that out. It goes a long way with listing agents because it's less work for them to have to do later. If you are constructing your offer through Instanet, it could pull the information directly from the MLS so that you don't have to fill that out. If you are filling it out through Brokerment, it's not going to auto-populate, so you will need to look up some of the information. If you're not sure about certain information, then you can just leave it blank and leave it there for the listing agent to fill out when they go to ratify it. I hope this helps. If you guys have any questions in the future, please feel free to reach out. It is 15 pages worth of fun and information, but you guys got this. Go sell some houses.